Hello, everybody, and welcome back to the criminal law. In the previous lesson, what we did was talk about the concept of the harm principle as a way of justifying criminalization of conduct. And this sort of ties into some of the basic theories and principles of the criminal law. Now, this lesson, we're going to essentially talk about the next of the major theories, or at least the second of the major theories of two, which is this idea of legal moralism and this idea of crime and morality. So, like I said, the previous lesson introduced the traditional theories of criminal law and criminalization. And we spoke at length about the concept of the harm principle, and this lesson we're going to talk about the concept of legal moralism. Now, ultimately, the concept of legal moralism, essentially the thesis that is presented, the argument which is presented by legal moralism, says the following. It argues that criminalization may be justified on the basis that the particular act in question, or the omission, or whatever we are looking to criminalize, violates some kind of moral standard or moral principle. That is a sort of general thesis. Of course, there are specifics in terms of specific theories within this idea of legal moralism, within the tradition of legal moralism. Some people may argue that legal moralism cannot ever be a sufficient condition for criminalization, or at least for justifying criminalization. And in fact, there ought to be other necessary factors which go along with it. However, this is just a sort of general thesis of what legal moralism states. Now, it also means that if it's something is a crime, it may be a crime not necessarily because it causes harm, but because it is immoral. Now, you might be of the opinion that every single thing or anything that causes harm can be considered to be immoral. And so you can almost have legal moralism as being a more all-encompassing criminalization theory to that of the harm principle. But the thing that legal moralism does is it takes it one step further and talks less about harm specifically, but talks more broadly about the idea of morality and moral standards. Now, the concept of the harm principle and the idea of legal moralism may even be encompassing be able to be encompassed into the idea of legal moralism. You could say, for example, murder is wrong, or at least murder ought to be criminalized because it is immoral and it is wrong. It is immoral and it is wrong because it causes harm. So you can almost have it as a two-stage test in that regard. Now, the question and the critiques that we can then start to think about is whether or not it ought to be the case that public morality be considered the remit for the criminal justice system. Should there be an interlinking, an interconnection between the criminal justice system and this idea of public morality? Is this idea of public morality sufficiently codified such that we understand it enough to be able to allow the criminal justice system to intervene within it? What about acts which are considered to be perfectly legal, but at least 30 years ago were considered to be immoral? For example, things like homosexuality. What about acts which are considered to be immoral, but are not taken up by the criminal justice system, and we would argue shouldn't, or probably ought not be taken up by the criminal justice system? For example, cheating on a significant other. These are both examples which really beg the question as to whether or not legal moralism can be, in and of itself, in its generality, an accurate principle for talking about justifying criminalization. Because on the one hand, you can criminalize conduct which is considered to be immoral, but in reality is completely legal and perfectly moral, like things like homosexuality. And on the other hand, you can think of things that I think the entirety of a public society would argue is an immoral act, like cheating on a significant other, but that ought not be taken up by the criminal justice system. We ought not to justify criminalization of adultery on the basis of the fact that it is immoral. So, one of the things that is very interesting with this and talks about the interrelationship and the interaction between this idea of public morals and the criminal justice system is the development of two offences in the 1970s which surround this idea of public morals. So there are two specific offences, common law offences, which were developed in and around the 1970s, and these were conspiracy to corrupt public morals and also conspiracy to outrage public morals. Now, In addition to this, the application of these offences can be seen in two cases, one concerning prostitution, the other concerning homosexuality. And let's talk about these in turn. Let's talk first about Shaw and the Director of Public Prosecutions from 1962. In this case, the defendant had created a number of magazines, and included within these magazines were the personal adverts for prostitutes to be able to advertise their services, and for that to be then advertised in the magazines. Okay, and given the fact that the defendant had made money from selling the advertising space, so this is something that is probably done less and less today owing to the fact that we have the internet, but back in the day, back in the 1960s, magazines were a very good way to advertise your products, to advertise your services in the case of prostitution. And so people who would distribute magazines or own magazines would make quite a lot of money from being able to sell advertising space. This individual here, the defendant here, had done so by selling advertising space for prostitutes to advertise their services. They were charged and convicted with conspiracy of conspiracy to corrupt public morals. Now, in addition to breaches of the Sexual Offences Act of 1956, so this is Section 30. So the thing that is more important for us is less the statutory offence which is attached onto this case, which is Section 30 of the Sexual Offences Act, but specifically this idea of the fact that they were charged and convicted of conspiracy to corrupt public morals. The defendant would appeal the conviction, at least appeal the conviction of the conspiracy to corrupt public morals, on the basis that, and given the fact that this was not considered an offence in the law of England and Wales, and so the defendant here argued that they ought not to be convicted of an act which is not actually an offence. The appeal was dismissed, however, and the conviction was upheld, and this therefore created a new criminal offence in the process, which was that of a conspiracy to corrupt public morals. A few years later, a very similar case takes place, which is the case of Knuller and the Director of Public Prosecutions again. Again, this was a case which involved the defendant publishing magazines for distribution. These magazines, instead of allowing people to advertise prostitution and to advertise their services as prostitutes, this magazine allowed people to advertise, individuals to advertise personally themselves for homosexual practices, essentially. I'm putting homosexual practices in sort of inverted commas, considered the kind of formalistic language that implies. Now, again, the defendant was convicted for conspiracy to corrupt public morals, along a similar basis to the previous case of Shaw. Now, the issue again was whether or not this was an offence which is recognised by England and Wales, and just like with the previous case, this was dismissed, and therefore reaffirming the creation of the offence and reaffirming the decision that was made in Shaw and the Director of Public Prosecution. Now, as you can probably understand, and as you would probably note, at least at the time, these were relatively controversial cases, but now these cases are both incredibly controversial, as you may understand. There was also scrutiny of these kinds of offences under the Wolfenden Committee report, which was in 1957, and it was the Committee report on prostitution and homosexual offences. And here what the committee essentially held was that the criminal law ought not have a role in the enforcement of public morality. And that given that morality is a subjective endeavour, as we probably know, without getting into the sort of depths of the meta-ethical theories of morality, we would note that morality is often considered to be subjective. It differs from one person to another as to what people view as moral versus immoral. There are some people today who believe that things like homosexuality is immoral. The regulation of public morality under something like the criminal law is something that could be considered to be controversial. And so as a result of this, it really leaves legal moralism in quite an interesting question. The question is whether or not we can justify criminalization on the basis of morality, or a lack thereof of morality in the particular act. And this is an interesting debate that will continue to be had, and when we get into looking at some of the philosophies of criminal law in more detail in future lessons' time, I'm sure we'll go into this in far more detail.